I'm not on my phone. I'm watching PowerPoint. I can't see it on fire.
That's fine. Tonight, we're going to talk about constitutional law and the principles and powers of government. So, what is the constitutional power of government? Well, the first thing we can address is something we call the Commerce Clause. It's actually written into the Constitution. It is written in the Constitution that the states are able to conduct business between and among themselves. So, what commerce can Congress regulate? Congress can regulate any commerce it wants, except purely intrastate commerce. Now, there's two types of commerce. Commerce comes in two flavors. It's like those old popsicles where you used to have one side that was lime and one side that was cherry. We have interstate, I-N-T-E-R-S-T-A-T-E. Interstate commerce is commerce that goes between states. So if I make something here in Nashville and I ship it to Kentucky, all the way up to Louisville, say, that is interstate commerce because it has crossed a state boundary. Any product that crosses a state boundary is in interstate commerce. Congress can regulate interstate commerce. Now, does it need explicit power to legislate for the good of the country? Anybody want to guess? Does it need to have it written into the Constitution or written into a statute to come up and say, let's legislate for something that is for the good of the country? Yes? No? No. Why would you say no? Do you know an example of when it has used, say, something like interstate commerce to legislate for the good of the country? This is going to surprise you a little bit. I say a lot of things that surprise you a little bit. Buses, trains, and airplanes go from one state to another, don't they? Okay, so back in the 1960s, we had a movement called the Freedom Riders. Have you heard of the Freedom Riders? What did they do? They rode the buses between states to establish the right of all minorities to travel equally with other customers, didn't they? Okay. Well, what happened was there were diners along the way, and they would get off, and the diners would have a sign up that said whites only. Well, everybody needed to eat, so the Freedom Riders said, let's sue on the commerce power, because Congress can regulate commerce between states. And aren't we riding between states? So that makes us part of commerce. We paid for our tickets. They sued, and they won. So that was the very first time that the U.S. Congress and the Supreme Court said equal opportunity applies to all individuals riding the buses or flying in airplanes or riding on trains because it's interstate commerce. That makes a lot of sense, doesn't it, when you think about it? Makes a whole lot of sense. That was not explicit in the U.S. Constitution. It just wasn't. It's not written in there. But they were able to get it judicially approved. Remember I talked about precedent in the first section. Precedent set it up, and when they got all these precedents under interstate commerce that the Freedom Riders and others set up, like our sit-ins at the lunch counters down here in downtown Nashville, when they got all of those put together, Lyndon Johnson signed a law that Congress promulgated. He sent the legislation to Congress, and they sent it back for his signature. That was our first example of equal opportunity acts. And it all started with interstate commerce. So Congress can regulate all sorts of commerce between states. So what does it usually regulate? Or don't the states have any rights? Well, they do. The states do have rights. It's what we call intrastate. INTRASTATE. Intrastate powers to regulate. And if it goes between, in Tennessee, if it goes between Bristol and Memphis, that's inside the state. And so they can regulate it because it's in the state. It doesn't go outside. If it were to go outside, if it were to cross the bridge into Arkansas, in Memphis, it would be interstate. But if it stops in Memphis, it's intrastate. Okay? Mm-hmm. All right. Pretty good examples. Mm-hmm. So let's talk about powers of government insofar as constitutional principles go. So we talked about the Commerce Clause. Now let's talk about anything the states can do, in addition, called the police powers. And the police powers say that a state may regulate even things that touch interstate commerce if there is a balanced interest against the burden placed on interstate commerce by state regulation. Police powers essentially are state restraints for protection of public safety, health, and morals, or promotion of the public convenience and prosperity. Some of the things that the states will regulate are things like water utilities, because most water utilities are regulated within the boundaries of the state, and they regulate for the safety, even if that water is piped out of state to a small town along the state border. Okay? So anything that's for the protection of the public safety, health, and morals, or promotion of public convenience and prosperity may be regulated by state government, so long as it does not have a chilling effect on interstate commerce. That means it can't stop interstate commerce or make it too difficult for states to trade between each other. Okay? Why is there such a problem with interstate commerce? You know, if something goes across state lines, if we send something from Tennessee to Kentucky, we know that's interstate commerce, right? Yeah. But we also have something called e-commerce, right? So what is e-commerce?
It's like Amazon, eBay,
Stuff you buy on the internet, you buy online, through social media, through internet sites. So when that got started, I mean, it was a great thing to have, wasn't it? But the government is always looking for what?
Money.
Revenue and money, taxes. So the problem becomes one of taxing, taxing, and more taxing. Right? So we have to sit and think when we're working with interstate commerce, if we're buying from, say, Amazon, if we're buying from, say, a private website, like the Hewlett-Packard website directly, or we're buying from Verizon, from their website, we have to think, well, if it's coming across state lines, it shouldn't be subject to state tax, right? Is that true? If we're going to tax something, and it comes from a website, should the website have to charge state tax? Okay, anybody say yes? If you're buying something on a website, should you have to pay taxes on it? Some people say no, some people say yes. So that means that you all are just as confused as the rest of the people. Why? Why are they confused?
I would say yes, because I mean, at the end of the day, it's a business.
The business, it comes from the business has to pay taxes. But what happens if you buy it from a website and it's shipped from Memphis to New Orleans? It's across state lines. Can you tax across state lines? No, not usually. If I drive to Kentucky and buy a TV set, my old Sony flat screen with the huge tube TV set suddenly blows up. And I go to Kentucky because I see a deal in a shop up there for a nice 52-inch TV that I can put up on the same space that I have that Sony on right now. Is my TV able to be taxed in Kentucky? Yes, sales tax in the state where I bought it. That's absolutely right. Can the state of Tennessee tax my TV set? Really? Okay, let's look at that for a second. It's not what you do, it's how you do it. See, it's in interstate commerce when I bring it back across state lines, right? Okay, but I bought it brand new in Kentucky. And it's brand new, it's still in the box. Right? It cost me about 5% sales tax in Kentucky. I'm only too happy to pay that because here in Davidson County it would be 10%. Right?
Yeah.
So, it's not whether we tax it or regulate it, it's how we do it. So let me explain the difference between a sales tax and a use tax. A sales tax is point of purchase. So where I buy it in the state of Kentucky, I pay 5%. I drive that TV in my car back to Nashville, across the state line into Tennessee, where I am going to use it, thank you, here in 1927. In 1927, legislators here in the state of Tennessee decided that they could get extra tax for things purchased in other states by establishing a tax on things that were going to be used here in the state of Tennessee. So, that TV that comes across in its brand new box, in a brand new condition, from Kentucky to Tennessee, we owe another 5% tax on that for use tax. Okay? Here's the catch with it. With a use tax, you have to declare it. Out of the good of my heart, I'm going to tell the tax department in the state of Tennessee that I really need to pay them another 5% of tax on that TV. So I have to declare it. And I urge you to declare all of your new purchases that you brought in from out of state for that tax. I would hate to see any of you get brought up on charges for tax evasion. Oh, it's everything. Everything. But let me tell you, what would happen if I decide to stop overnight at a friend's house in Bowling Green? And he says to me, how can you be sure that TV works? Have you tried it? And I say, no, they just handed me the box and I walked out of the store with it. He says to me, for such a smart man, that wasn't a very smart thing to do. Let's take it out of the box and plug it in and see if it will work. So we do. We take it out of the box, plug it in, and turn it on. He hooks it up to his HDMI, and we watch 2 or 3 episodes of Game of Thrones. Or if it's Friday night, we get the Sci-Fi Channel, we watch Killjoys. Now, what's the difference between the taxation that I would pay in Kentucky and in Tennessee now?
So you pay use tax for Kentucky and
No?
I think it's based on system, tax at the state, then it's
Okay, so what do you
tax.
mean?
Unless if you bring it out of state to another state, you get to use that.
All right. Who else? You were saying something, too. No?
So would it be zero because you plugged it up and used it then first before you run it back to Tennessee?
That's exactly right. It's no longer new. If I plug it in and take it out of the box,
in the same state that you bought it in.
in the same state that I bought it in, it's now a used item, and I can just leave it out of the box, put it in the back seat, and if somebody stops me and said, where'd you buy this TV? I said, I bought it in Kentucky, and I've been using it in Kentucky, and I'm just going to take it back to my place in Nashville now. But my friend had got me using it, and I liked it, and so I took it out of his house and brought it here. Is any of that not true? No. I recently had that very thing happen with a VCR. You remember VCRs? They used tapes instead of DVDs. I had a VCR that was in my father-in-law's house up in Ohio. And it was all in its brand new carton, and it was all sealed up and everything. And my wife says, I'm going to bring this home. I said, does it have a receipt with it? And she said, yes, it does. I said, well, you better bring the receipt because we're going to owe use tax. And she says, are we really? And I said, yes, really. We're going to owe use tax on it. So we're going to have to pay the difference between what your dad paid for it years ago and what it's worth here now on the sale. So she brought it back, and we opened it up, and lo and behold, not only was it used, it was broken. So I had planned to run all my old VCR tapes on that thing, you know? And I can't do it. No more Star Wars for the professor. So, that's sales tax versus use tax. Then we have something, privilege tax. And that's versus a tax which affects interstate commerce. Now let me tell you what a privilege tax is. A privilege tax, the way I'm using it here, is a tax which allows me to do something. Every year, I have to pay $400 to the state of Tennessee to maintain my law license. That is a privilege tax. On the month before my birthday, I have to pay the state $400 to maintain my law license. That's a privilege tax. Anybody here have any experience as a beautician? Nail salon? Massage therapist? Veterinarian assistant? Anything that requires any sort of a state license has a privilege tax fee of $400 annually. Now I can see me paying that as an attorney. I can. But I can't see charging $400 for someone who works as a veterinary assistant who doesn't make that kind of money, you know? It might take them a whole week or two, depending on how much they work, to accumulate what the state of Tennessee is charging them in privilege tax. But that's what it is. How does that affect interstate commerce? Well, if I want to go to another state, yeah, Larry, go ahead.
Does that apply to like district attorneys, people who like work for the state, would they have to pay as well?
Yes, they do.
Now, to me, that's not fair.
It is a tax on the licensing, not on the position.
So if you get like a business license or like a wholesale license, so like tobacco license, you have to pay the same thing. Is that a privilege?
That's different. No, that is different. It's a different kind of license. If you are, say, a distributor for fine wine, you pay taxes on each bottle of wine that comes in that case. And it has the stamps on it, the revenue stamps. That means the tax has been paid on that wine and you can resell it in the state. Here's a funny story that goes along with that, because that's a good question. About 10 years ago, you know, we have a paddle wheel steamer that runs the length of the Tennessee River. And it's a pleasure cruise, and people buy tickets on it, and they take a cruise on the river, and it's a paddle wheel steamer. It's really nice, very relaxing. They have ports of call in various cities and towns. You go in, and there's a whole industry built up around entertaining tourists on this steamboat. And they made an amazing mistake. They forgot to pay the revenue tax and get the revenue stamps on all of their wine, license, and beer that they had on the steamboat when it crossed from Kentucky into Tennessee. So all of their libations were not only confiscated, and they had to pay a fine, but they dumped them in the river. So nobody could use them. This was 10 years ago. I don't know. The scene of pouring a really good Guinness stout into the river just hurts my heart as an Irishman, you know? So sometimes privilege taxes will actually affect interstate commerce. Now, what do we say about interstate commerce? If we have something in commerce that goes from one state to another, it should be free of tax, right? Okay. But you are a medical doctor, and you practice law at the St. Jude Hospital in Memphis, and also at the University of Arkansas Medical Center. There's a privilege tax in both of those states. If you pay it in Tennessee and cross the state line, do you have to pay it again in Arkansas?
Yes.
You're brilliant. That's exactly right. Yes, you do.
Practicing in another state.
You are practicing in another state. That is exactly correct. Okay.
So they don't have like a federal privilege tax, so you go anywhere around the country?
There's a thing called a value-added tax, or VAT, which Congress thought about enacting when the internet was established, so that the federal government could tax all the goods in interstate commerce that came off the internet, but the states could not. This would have eliminated state income tax, and then the federal government would then rebate by percentage of sales and population monies from the value-added tax, the VAT, back to the states. That proposal never went anywhere because you know that some states are less populated than other states. So they would not get as high a per capita share of the tax revenues from sales as some other states. For example, Alaska. There are more moose in Alaska than there are people. So everything that they buy in Alaska, and they buy a lot of things in Alaska because, you know, you need big fluffy jackets and skis and snowshoes and snow shovels, lots of snow shovels. You need all that stuff, and you pay sales tax on it. Well, if it was a value-added tax and the federal government collected, and it was going back to the federal government and then being reallocated, some of the money from your state might go to California because they had a higher population. So that discussion has been going on for a really, really, really long time. And I don't see any end to it. Now let's talk about when interstate commerce starts and when it stops. So let's say that we're going to place an order for something that's typically made in the United States. Let's say we're going to order a sofa that's made in Burlington, North Carolina. They have a big furniture industry in North Carolina. We order a sofa. Sheree, what's that sofa going to look like? A big sofa. Is it going to be soft and fluffy? Comfortable.
Kind of firm a little bit. You don't want it.
Firm. You're going to have. Is it going to be leather?
No, it's fine.
Fabric. Okay. So you're going to have a really high-end sofa, big one. So what you do is you place an order for that sofa. The order is usually placed through a retailer because you're in the showroom and you're looking at the various types of furniture and you say, well, I like this fabric because you specified cloth. And I want it firm, so you want a little extra stuffing in it. So you're specifying all these things. You have to order it in the shop because when you do it online, it just doesn't come out the same for something that's custom made like that. So you order your custom made sofa through the retailer. The retailer then either wires it or phones it into the manufacturer. Is it in the stream of interstate commerce yet? No, it is not. You're absolutely right. You're absolutely right. The manufacturer has received the order. They print up the order. They type it all up, and it's on this big long form. And they put it on a piece of wood that's going to be one of the supports for the sofa. Is it in the stream of interstate commerce yet? think so. But remember, there's always several ways to look at things. In this particular case, a minority of states, that's a small number of states, is going to say as soon as the order goes on to something that's going to be a part of that SOFA, it's in the stream of interstate commerce if we know it's going to leave the state and go back to the other state. See, because we're here in Tennessee, manufacturers in Burlington, North Carolina. So there's a sticker now on a piece of wood that's going into the manufacturing process. And some will say it's in the stream of interstate commerce. Most of us say no. You were right about that. Most of us say no. Generally, you're safe if you say it's not in the stream of interstate commerce because it hasn't gone anywhere yet. So, goes through the manufacturing process and it gets put on the train. Gets put on the train. Is it in the stream of interstate commerce yet? No. Those of you shaking your heads no are correct. Why is it not?
It has been processed.
It hasn't gone anywhere yet. So now it's going to go from North Carolina to South Carolina. It's crossed a state line, and then it's going to go into Georgia, and then it's going to go over into Alabama and Mississippi, and it's going to head toward Tennessee. Now is it in interstate commerce? Everybody agrees that now it's in interstate commerce. It's crossed multiple state lines. But even if it crossed one, and they unloaded it and put it into a storage facility for 2 weeks, it's still in interstate commerce. So, finally, it's going to enter the destination state. Now, why are all these determinations of when it's in interstate commerce important? Because some state is going to want to do what? Tax it. They're going to want to tax it as inventory. Inventory taxes can be really high. And that brings some money in for the state. So they're going to want to determine when it's in interstate commerce and when it's not. It's in the destination state. Is it still in the stream of interstate commerce or not? You're saying yes, and you are correct. The reason it is still in the interstate commerce is it has not come to rest in the state, in the possession of the retailer who will then call Shree to have her come pick up her sofa. But it's now going to be put into the retailer's warehouse. Is it at rest?
Yeah.
Yes. So what can the state of Tennessee do? Tax it. Now the state can earn sales tax. And who gets charged for that sales tax? Shree does. Shree gets charged for the tax. Oh, but what if it stays in the, just as an aside, what if it stays in the retailer's warehouse to the end of the fiscal year? That could be a day, it could be 2 days, it could be 3 days. What happens to it in the warehouse? Inventory tax. It's part of the retailer's inventory. It doesn't belong to Shree yet. She hasn't taken possession. Remember they say possession is 9/10 of the law? Possession is also 9/10 of who pays the taxes. Okay? So that's where all of this comes from. That's where interstate commerce ends. It starts somewhere in here and ends over here with the consumer. So, we know that items in interstate commerce are subjected to general regulatory powers of the state if the company doing business has some sort of physical presence in the state. Our retailer for the sofa had a store. The store is made of bricks and mortar and block and steel and paint and glass and steel. It is a physical presence. So how do we collect taxes from the internet? Somebody, please help me here. My state program is dying for lack of money. How do I get taxes off things that we buy on the internet? Somebody tell me. Not gonna tell me, no. On transport? Could you tax it on transport?
Yeah, I think so.
If it's intrastate, the hauler who's carrying it intrastate has to be licensed, right? So there is licensing on their vehicle. Okay. But let's figure this out. There's a case called International Shoe versus the State of Washington. International Shoe versus the State of Washington. And here's how this came about. There was a shoe salesman. And years ago, salesmen would go around their territories with samples of things, and they would sell to customers. So, this shoe salesman had a case full of little tiny model shoes that looked exactly like what this year's fashion success shoes are going to look like. Right? But they were tiny. Even a baby couldn't wear them. They just looked like stuff. They were made of leather and everything, but they were just models. And he would go around to people's houses, and he had a bunch of regular customers that he would go to that bought shoes from him. And so, what happened? He would take out his measuring scale that has right foot, left foot. You've seen these? You put your foot on it, and it gets the width, and it gets toe length, and you know what size you are. He would custom measure all of his customers for new shoes and take their order. And this particular customer service representative went from the state of Washington to the state of Oregon, down into the northern part of the state of California. Well, the state of Washington said, you've got all this stuff in your car that's just like a shoe store. We're going to take you to court and make you to pay state taxes in the state of Washington. Of course, you know how that would go. Then he'd have to have paid in the state of Oregon and in the state of California. International Shoe didn't want to do that. So they sued International, and they took it all the way to the Supreme Court. And what happened? When that finished out, it said, guess what? You owe, Mr. Salesman, you owe taxes to the state of Washington. Why? Because that case full of those little bitty shoes and that measuring device was just like going to a shoe store. It was a functioning business. It was a well-functioning business. The reason they sued him was because he made a lot of money.
He didn't give almost $7 million.
He didn't give anybody except,
How much money do you need?
I'm not sure exactly. I remember it was in the hundreds of thousands of dollars a year. And this was back in 1945. Yeah, back then it was like $50,000 was like $350,000 now, just because of the change in inflation and all that sort of thing. So what the Supreme Court did was establish conditions under which a traveling salesperson or someone who does not exactly have a brick and mortar store where customers come into the store itself establishes them as a business. First of all, it said the presence can be a store, an actual store. It can be a traveling salesperson, or it can be any presence that provides the criteria necessary under International Shoe versus the State of Washington. There are 9 elements of minimum contact. Now, does Amazon have a store in Tennessee? Does Amazon have a store? Distribution center, but have they recently bought something that gave them a physical store?
Yes.
Yeah, that's in Seattle. I didn't know.
Yes.
Aren't they trying to bring like their headquarters here, right? Tennessee was
It's in their sites for the headquarters, but this is even more important than that. Didn't they buy Trader Joe's?
And Trader
They bought Trader Joe's?
They bought both. They bought both.
Look it up. Somebody look it up. Somebody look it up. I said we were going to do this, and there was a question on it. Who bought Trader Joe's? Shout it out when you get it.
It says that Amazon bought Whole Foods hurting treatment.
Yeah, that's the first one on the side.
It says they're hurting Trader Joe's?
Yeah, they're Trader Joe's because they're lowering the prices in
Whole Foods.
Yeah.
They bought Whole Foods. Thank you,
Yeah,
Julie.
I was like, I don't think they bought.
They bought, so now is Whole Foods, since it's a brick and mortar store, does it qualify Amazon as being at a sales tax collecting store?
Yes.
Yes. Yes, it does. So one of the things that we have to establish is, does the internet or an internet presence where things are being sold establish a brick and mortar business? Now, we have some very interesting states in the United States. There's some very evolving law that comes out of the northwest central area. Utah, Idaho, Wyoming, and Colorado in particular, having to do with the internet. And one of the decisions, or several of the decisions that have been coming out of those states, say that having an internet page up on your computer in your home is just like having a traveling salesman from a company in your living room. What do you think of that?
No.
I think it's a bit of a stretch.
It may be a bit of a stretch, but almost every state in the United States has upheld that. Because you can go through items, you can pick sizes, colors, put those interesting multicolored shoelaces in them if you're buying shoes. All sorts of things. About all sorts of stuff. So having an internet page open on your computer is now like having a brick and mortar store in your living room. And they can collect sales tax. That's why every state now is charging sales tax on internet items. And the companies are going absolutely crazy trying to figure out what they should be paying to each state. It's all computerized, fortunately, and it makes it a little easier, but it's nonetheless aggravating. Yeah, Zach?
Okay, what about in the case where there's like a digital exchange going on for something that was another digital good, like let's say we're not ordering like shoes or something, we're ordering, a e-tax book or something. Does the sales tax still apply in that situation?
That would depend. I like the phrase, "it depends," and you're gonna hear me say a lot of that this semester, because in each jurisdiction, there may be a different ruling. For example, I buy a computer program. It's a digital good. I download it onto my computer. I pay for it. Do I owe sales tax on that?
Yes.
Yeah, but you pay.
I could, depending on how state law is defined, or at the very least, I could have to pay, what's the other one? Use tax. Because I'm downloading it, I'm using it, I've paid for it, I owe somebody some taxes someplace. Okay, now here's the thing. Is use tax another term for sales tax? It sure is. It sure is. And it just depends on how it's defined in state law. In 1927 in Tennessee, we defined what a use tax was. And it's the difference between the sales tax in the state in which an item is purchased and the amount of tax that would be due had that item been purchased in Tennessee. And it's going to be used in Tennessee. Okay? Does that seem to fall into place? Okay. Any questions on that? Any questions on international shoe? You can actually read that.
So like you said, in 1927, so what's gonna happen if I buy, like a shoe from, let's say, the TV in Kentucky, and it's 10% tax, and it comes to Tennessee, and it's like 5% tax? for sales
You're not
tax?
going to get a rebate. No, if you buy something in a state which has a higher sales tax, and you come into Tennessee and it has the lower sales tax, you do not get a rebate. You've paid the sales tax at the point of service. Use tax zeroes out. Okay? Okay. I'm sorry I had to disappoint you there. So, websites accessible from any location, are they sufficient for a state to exercise police powers and jurisdiction? Right now, the states are saying yes. The federal government is saying yes. The manufacturers and the retailers and the merchandisers are saying no. So there's going to be an argument that's going to go on. And I think there's still a suit going on with the Federal Trade Commission that involves that particular question. But right now, sales tax are in effect. Supremacy Clause. Supremacy Clause is another part of the U.S. Constitution, which is enumerated on the face of the Constitution. It is actually written into the Constitution. It applies to concurrent state and federal powers and conflicts of powers between the states. It results in the doctrine of what we call preemption. Now, we had a question in here during our very first session asking, do some laws knock out other laws? And I said the answer was yes, and we would get to it when we talked about constitutional law, and I would show you a chart of what knocks out what. Okay? So what knocks out what is called preemption. It works with power, conflicts, taxing, and spending. If the federal government taxes something, the state can't tax it. So, why do we have federal income tax and state income tax? Wouldn't want the federal government knock out the state income tax? Seems like it ought to, right? It's on income, right? What could possibly be the problem where we have income tax being taken by the federal government and by the state government?
Civil?
It has to do with something that is different.
Oh, the percentage rate is different?
The percentage rates are different and the wording of the statutes are different, that's all. And they can do that because apparently the federal government taxing income is not the same thing as the state taxing income. And the rates are different. So, and we'll talk a little bit more about that same, not same stuff here as we go along in the next few minutes. Federal regulation preempts similar state regulation unless the state regulation has harsher penalties or is worded so that it's even slightly different. So federal income tax is worded slightly different from state income taxes, so they can take both of them. Right? Let me talk about another one. And this one is a little bit easier to see. The Environmental Protection Agency. The states have environmental protection agencies, do they not? The federal government has a federal environmental protection agency, does it not? Are the statutes the same?
Yes, but they weren't.
So similar that if you superimposed one over the other, they would look the same, except what, Larry?
No, my question is, why would they be the same? Because the federal government is higher than the state government, so
That's right.
why would they be the same?
Because the federal government can't be everywhere at once. And the state has its own inspectors and regulators ready to go out and regulate whatever it is they're talking about. That's in addition to what the federal government has. What is different? I have personal experience. I have personally preempted a federal regulation in the environmental area. When I worked for the state department which regulates electricity, natural gas, and water, and telephone service, I preempted a federal government statute because the federal statute had an article, the word "the," T-H-E, in a different place than our state statute did, which made our state statute more effective. So it was worded, and it says slightly different. If that wasn't slightly different, I don't know what is. So we have the EPA, and the EPA regulates certain areas. And they say, we're going to fine you $5,000 a day for certain actions. State regulation says, we're going to fine you $50,000 a day for certain actions. They both regulate in the same area. That's called concurrent regulation. But which one would overrule the other one?
The state for the harsher penalty?
The harsher penalty overrules. So the state would overrule the federal regulation. Sometimes it's the other way around. Okay? So when we look at various laws, what kicks out other laws? This was what we were talking about in session 1. We had a question. I don't know. I think it might have been your question. Somebody asked, what laws Or were you just stretching? Other laws preempt certain laws. So what preempts? The U.S. Constitution will preempt or knock out the state constitution, any concurrent state statute, and any concurrent state regulation. So the U.S. Constitution will knock out everything. If the Constitution gets out of bed this morning and says, I don't like that law down there in the state of Tennessee, it's gone. What do federal statutes preempt? They preempt concurrent state statutes that are similar and concurrent state regulations. No more cat videos on the internet coming out of Tennessee. Well, the federal government has a statute which says, yes, we'll have cat videos on the internet. But that knocks out the one that says no cat videos. It also knocks out the state regulation which says the cats have to be over 4 pounds. There are just too many cat videos on the internet. Have you noticed?
No.
No? You like the cat videos on it?
No.
No, you don't like them. Okay. We'll just knock them out. Knock out the videos.
Is it the same thing like the city? Like the state, you know, there's a city like the federal?
Yes. The same thing happens with local regulation. The U.S. Constitution knocks out the state constitution, the concurrent state statute, the concurrent state regulation, and all municipal regulations below it, and municipal laws. The state constitution can knock out all municipal laws. All concurrent state statutes can knock out all municipal regulations, and concurrent state regulations can knock out state regulations and municipal regulations. Here is one, a story that came when I was with the Tennessee Regulatory Authority. This came across my desk. I had 3 federal attorneys come into my office to argue with me that a hydroelectric power plant that was operating purely on municipal land should be dismantled under state action because it conflicted with the Tennessee Valley Authority. Okay, now this municipal generating facility generated maybe enough for one building, and it was completely on state land. It was state-owned. The power didn't go off the state facility, and the federal government was arguing that we should give them an order to shut it down because it conflicted with federal law. Does that make any sense? No, it doesn't. Let me tell you, there's something that is very important in state law that applies also to municipal law. We have something that certain cities have powers in the state constitution which gives them special status. It's called home rule. Home rule cities can take something away from the state and legislate it and take care of it because it's in the Constitution that they're a home rule city. So the state constitution can't touch a home rule city. This power plant was in a home rule city, so the state could not take it away. And I told these federal attorneys, if you want to do that, If you want all that negative publicity, if you want to lose the cooperation of Metro Davidson County, don't look at us to help you with it. We're a state authority. We know what a home rule city is. I suggest you leave them alone. They did. Now, federal statutes then, whoops, sorry. Federal statutes knock out concurrent state statutes, and federal regulations can only knock out state regulations. They can't knock out anything up here. It just comes straight across to concurrent state regulation. Okay? Let's talk a little bit about the Bill of Rights. The Bill of Rights is a major part of the U.S. Constitution. What do we have? The Bill of Rights, the first 10 amendments to the U.S. Constitution. The first thing that we always think of is freedom of speech. That's the first thing we always think about is freedom of speech. Now, freedom of speech is a right which accrues to naturally born U.S. citizens. What do I mean by naturally born? You were born here in the United States. That gives you freedom of speech. Is all speech free? No. Tell me one time when freedom of speech does not apply. Hate speech. Very good. What else? Well, that's a right that comes under the Fifth Amendment. We're talking First Amendment here. Hate speech is a major one. Yeah? Yeah? The one that I always think of is fighting words, and that comes under a similar version of hate speech. Fighting words is when someone incites individuals to immediate violence. Freedom of speech does not apply to that. So what's the difference between the freedom of speech and commercial free speech? Can anybody tell me that?
With commercial free speech, has to do with non-American born citizens, and naturally born Americans.
No. Anybody want to take a crack at it? Commercial free speech. Commercial. What's on your cup? It says Smoothie King. Is that free speech? Can you put the Smoothie King label on a Smoothie King cup? How are you able to do that?
Freedom of commercial freedom?
They were commercially free to do that. Commercial free speech, though, is limited. It's limited by regulation and law. You have to tell the truth. With freedom of speech that is commercial, if that says Smoothie King on it, there better be a smoothie. That is a rule. You have popped snack mix. What if you opened it and it had gummy bears in it? Is there a problem with commercial free speech here?
Yes.
Maybe. If you didn't like the gummy bears, then there would be a problem. Then you could complain. But if you like the gummy bears, yeah, you're not going to say anything. Especially if the gummy bears that were right next to it cost more than what you buy. Corporate political speech. What is corporate political speech?
Is the other person's views on politics or something that's sort of
A person's views on political topics made by a corporation. Corporations are allowed to express political opinions. Often they are made through what? Endorsement and contributions to political causes and candidates,
Like Alec?
like anybody. Okay? It used to be that corporate political speech and contributions were highly regulated. But the Supreme Court came in a couple of years ago and said, no. We're going to do away with that. Corporations have the right to express their views just like anybody else, and we're not going to restrict their contributions. Freedom of religion. Freedom of religion. The freedom to practice one's religion as one sees fit. Now we get into self-incrimination and the Fifth Amendment. There you go. Self-incrimination. That is the Fifth Amendment. We're going to go through each of these amendments in some detail here. And searches and seizures. Whether a search and seizure is legal or illegal is covered under the Fourth Amendment to the United States Constitution. So, what does the First Amendment do? It protects freedom of religion, freedom of the press, freedom of speech, and peaceable assembly. Yes.
I have a question.
Okay.
So what if, like, you know, the alt-right, like, protest movements, that's considered a peaceable assembly even though it's hate speech?
Okay, I was interrupted by a large person walking in front of me. Say that
So,
again.
like, you know, like the alt-right, white supremacist rallies?
The alt-right rallies.
So that's considered a peaceable assembly even though it's like hate speech?
Peaceable assemblies are by definition peaceable. That means there is no hate speech. They conduct themselves in a gentlemanly and gentlewomanly fashion. They have the proper permits, and they do not harass or intimidate anyone along their route of march if they are marching, or in their area of protest if they are protesting. That is what peaceable assembly is. The first time somebody throws a punch, it is no longer peaceable assembly. It ensures that citizens have the right to ask the government to redress grievances. This is what we do with petitions. This is what happens when we write our congressmen. This is what happens when we write our state legislators. This is what happens when we file a suit against the government in order to get our position heard. But freedom of speech and press are restricted. They are restricted by fighting words and juridistic persons. What is a juridistic person?
Angry?
Say it again, Larry.
Angry?
Angry? No. What is J-U-R-I? What does that sound like? Jury. Juridistic persons are judges. A judge can issue a gag order on a particular legal action. Why would they do that? Keep information from being leaked, which could otherwise affect the outcome of a fair trial. So, freedom of speech can be restricted in certain conditions, and they're very strict for a gag order. It has to be applied for, and there have to be really important and solid reasons given for that.
You mean like the basketball players get divorces and they get like a gag order on what they explain?
That's not a gag order. That's not a gag order. That is an order which requires the individual parties to stay so far apart or not to threaten each other.
I'm saying like where they can't speak on anything that happened in that relationship.
Generally, that is not given by a court. That is generally agreed upon in a contract or an agreement between the two parties.
Like NDAs?
Mm-hmm. Okay. And freedom of speech can be restricted where the need to discover in court with no alternative means to achieve the same information. In other words, if someone is going to be brought in to testify, and the testimony is based upon information that was given by a confidential informer, the individual who received the information can be ordered by the court to produce the original person and have them testify. Okay? Now, here's something that doesn't enter into a lot of political science discussions or business law discussions or sociology discussions. The meaning of the word of. Freedom of speech. Freedom of religion. Whenever of appears, there's a prefix occurring in a loaned word from Latin, that is to decide, decidere. It's also used to indicate privation, removal, and separation. Dehumidify, negation, demerit, derange, dissent, reversal, detract, or a decompound. So, what is that saying? It says, when we say freedom of speech and religion and press and peaceable assembly, can also mean freedom from or separations between religions and government, limitations on speech, and protection from assembly by those not peaceable. So we have assemblies which are not peaceable. So the freedom of peaceable assembly, other people are protected from an assembly which does not remain peaceable. Religion is a big one now. Separation between religion. We have freedom of religion. That means we also have freedom from religion. If we don't want to practice any religion, nobody can force one on us. That's a part of our Constitution. We cannot be forced by the government to do anything that we don't want to do. Freedom of, or freedom from the government. So, when we see of in the amendments, we're also including at the same time the words from, so that we can be protected from the same things that we're guaranteeing to others. In the Citizens United was a case decided by the U.S. Supreme Court. Corporations were given equal speech rights. That means they are able to contribute as much money as they want to political candidates, and however many political candidates they want. They used to be restricted to $10,000 per candidate. They are no more. Corporate funding of political campaigns without limitation of the amount of those funds is available, and they can sponsor ads, they can sponsor any kind of speech that we could be able to entertain as natural born people in the United States. What does our Constitution say about freedom of religion? Thomas Jefferson, very pointedly, when he was writing the Constitution, said, Christianity neither is nor ever was a part of the common law. In every country and in every age, the priest has been hostile to liberty. What is he saying? He's saying that in order to have the constitutional guarantees spoken of in the Bill of Rights, we need to separate religion and government. The government of the United States, John Adams says, is not in any sense founded on the Christian religion. That's why we have freedom of religion. All religions are welcome in the United States. Thomas Paine said, all national institutions of churches, whether Jewish, Christian, or Turkish, appear to me no other than human inventions set up to terrify and enslave mankind and monopolize power and profit. Thomas Paine, one of our constitutional philosophers. And James Madison, religion and government will both exist in greater purity, the less they are mixed together. He thought that religion and government would be more free if we kept up the separation of government and religion. Second Amendment. Second Amendment is the favorite of a lot of folks. Questions? Comments? The Second Amendment finds that in light of the need for a well-regulated militia for security, government cannot infringe on citizens' right to bear arms. What does that mean? You have a right to carry. Can that be restricted by state governments?
Yep, California did.
It certainly can. Why? Because the state's intrastate can regulate what? Under the police powers of the state. Safety, health, well-being, and prosperity.
They should change that.
Hmm?
They should change that. I mean, I agree with the government should make the decision. Everyone should have the right to bear arms.
Everybody right now, everybody does. Within certain I saw a law was introduced into the Tennessee legislature that gave people the right to open carry military-style automatic rifles.
That sounds like a great idea.
Yeah, it sounds like a great idea, doesn't it? That's what we need. No, if they do that, I don't know what we're going to do. No, actually, it was defeated. It was defeated. That was defeated by the state. Summary of the Bill of Rights in the Third Amendment. That provides that government cannot house soldiers in private residences during peacetime or during war, except for certain provisions in the law. Used to be, back in the Revolutionary War, the British Army would move into an area and they would send their soldiers to live with the individuals who lived in the town. Every family would have to take in one or two soldiers. They clothed them, they fed them, they took care of their horses, they cleaned their firearms, they just did everything that the soldier wanted them to do. That was a requirement that the British had. So when our Constitution was written, our constitutional founding fathers said, that's not fair. The military should provide for itself. And that's where the Third Amendment came from. And it has come down, you think, well, isn't that antiquated? Well, out in Arizona, a couple of years ago, the infamous Maricopa County, anybody else heard stuff about Maricopa County? Some of you have. Look it up. It's very interesting. Also extends the amendment to the use of surveillance or stakeouts in family neighborhoods where law enforcement tries to commandeer property, like real estate. Here's the case that this is about. The police knew there was a house out of which was being sold illegal pharmaceuticals. I'm not talking about drugs like heroin or crack, or anything. This was opioids. And they were selling pharmaceuticals which otherwise would have been legally used and possessed by individuals, was being sold out of that house. And so the police decided to set up a steakhouse. And they went in and they commandeered a room in a neighbor's house where they could set up a camera and binoculars to watch everything that went on in the house. And they filmed everything in there. Well, the homeowner, and this was without compensation, they didn't pay rent, they didn't buy food for the family, nothing. The family said, you're going to get out of here or we'll kick you out. And of course, the police were not too happy about that. And so they went to court. They got a restraining order and they sued. So the police had to leave because of the restraining order. They couldn't do anything to them. And they went to federal court, and lo and behold, federal court said, that violates the Third Amendment. You can't take property like that for a paramilitary. Now it has been expanded to law enforcement and paramilitary practices. So we never know when one of these amendments is going to come in handy, you know? This one hadn't been used since the 1800s, and now look. We're using it in the 2000s. The Fourth Amendment protects citizens from unreasonable search and seizure, such as stop and frisk. Stop and frisk involves something that is been ruled illegal by courts of law and appellate courts for some time. It's called profiling. You all know what profiling is.
Yes.
He looks suspicious, I'm going to pull him over and frisk him, no matter what he's doing. Well, stop and frisk was just that. They would profile someone and they would look for suspicious behavior based on a profile. But you notice I have something else up here. Innocent behavior. Let me tell you a story. This is one of my favorite stories that I actually observed when I was over at Vanderbilt. I was outside Satco. You all know what Satco is?
Yes.
San Antonio Taco Company. Do you like Satco?
Yes.
They have some pretty good food over there. And I was outside Satco. It was 4 o'clock in the afternoon. And there were a bunch of very boisterous, wonderful young people, some of whom I knew, who left Satco, and they were carrying, because they had eaten something that was extremely well peppered and chilied, they took water with them in containers. And a Vanderbilt police officer pulled up and motioned all of them over to stop and asked for their IDs. And they said, I'm going to have to search you because I believe that you are carrying alcohol in those containers and you need to come with me. They were just walking down the street. Yes, they were singing. Yes, they were skipping and doing things that other young people like yourselves do all the time. Playing music, singing along. I even do some of that stuff myself. The skipping and singing along part is my favorite. And I was standing there. I was watching this. And one of my students said, oh, that's one of our law professors, Professor McNamee. And the police officer immediately turned pale. And one of the students motioned me over and said, the officer stopped us for suspicion of carrying drugs. And the first question I asked him was, what's your probable cause? Well, that was the second question I asked. The first question I asked was, do you want to retain me as your lawyer? And here's the thing about retaining someone as your lawyer. You don't have to give them any money right away. All you have to do is they answer the question, yes. So if you had your lawyer in the area, at that time I was practicing law, I don't practice now. But I was walking down and they said, oh, Professor, can you come over and talk to this officer? And I said, do you want me to act as your lawyer? They said, yes. He turned even more pale because I said, officer, state your probable cause. He had to answer me. He had to answer me. He could have alleged that they were resisting arrest or something if I hadn't been there, but I said, you have to answer, officer, what's your probable cause? And he said, well, they have things in their cup. I said, that's not probable cause. This is innocent behavior. And if you insist on this, I'll have your badge. Let me finish the story. Let me finish the story. This is something a lawyer can do that ordinary civilians cannot do. Because I did show him my law identification card from the Supreme Court. He let him go. And I said, don't let me see this again. About 5 minutes later, I was standing in front of the Vanderbilt chief's desk. I don't know what happened after that, but I understand it was quite interesting. But several nights later, instead of being on a Tuesday afternoon in broad daylight, it was 2 a.m. and there were people coming out of a nearby sports bar. And they were also students at Vanderbilt. And they were also quite boisterous and quite loud. And they were carrying containers as well. And 2 of them fell into the street and nearly got hit by a car. It just happened that the police cruiser was right back of that car. And when they couldn't get up right away, the police officer determined that they might be intoxicated. Now, he had the right to make sure they were being safe. So he inquired, determined they were intoxicated, and they were taken in and were given a citation for public intoxication. And they had to go to court and pay that off. They got a nice lecture from the judge. So there's a difference between innocent behavior on stop and frisk and behavior which provides probable cause. It has to be something that any reasonable person would perceive as being probable cause. Okay? Government only can issue a warrant with probable cause. That is under the Fourth Amendment. They can also seize property only with a warrant and probable cause. If someone is arrested for mail fraud, the individuals in the investigating agency can take their computers to investigate with presentation of the proper warrants. We'll talk about what a warrant contains and how probable cause affects possible jurisdictional and juridical questions when we talk about the judicial process and criminal law. Okay? What we want to ensure is that government does not put citizens on trial for nothing. Normally, citizens are indicted by a grand jury. Sometimes grand juries conduct their own investigations of things. Anybody know of a recent grand jury investigation in Pittsburgh, Pennsylvania that has caused quite a stir? Yes, it is. The Catholic Church, of which I am a member, has for many years been condoning and covering up the abuse of youth and adults by individuals involved in clerical orders and administration. So the grand jury convened and began investigating. And they found that over the space of 30 years, there had been more than 1,000 incidents of molestation. And there may have been as many as 300 plus clergy involved in the molestations. Now, that's the investigation. Grand juries investigate. Then what do they do to hold people accountable? They issue indictments, which bring those individuals under arrest into court for trial and possible conviction. The Fifth Amendment also gives citizens the right not to testify against themselves. It's a privilege against self-incrimination. Corporations, on the other hand, if it is confined to corporate matters, must testify against itself. So Monsanto, when it was put on trial for putting chemicals together into various compounds, which were then spread on various bushes and trees and weeds and that sort of thing, and it made individuals ill, when they were put on the stand, they had to testify that the corporation knew, that the corporation did nothing about it, that the corporation did not issue warnings, the corporation did not pull the products. Now, what line is out there for that? When does that stop? It stops when the questions become personal. Did you formulate the chemicals in that particular product? I'm sorry, I'm pleading, I take the Fifth Amendment. I do not have to answer that question on the grounds it might tend to incriminate me. That's the line between corporate testimony and personal testimony. Corporate rights and personal rights. There's also a part to this right not to testify against themselves that has been sort of lost in the last few years to history. That's the right of a spouse not to testify against their spouse. Husbands and wives used to be prevented from testifying against each other. Not anymore. I think every one of the 50 states allows, say, husbands or wives to testify against each other. They waive the spousal immunity. Some of it is done by law. But that is kind of quietly gone by the wayside, and everybody testifies now. The Fifth Amendment also prevents the government from trying citizens twice for the same crime. We call that double jeopardy. So if a person goes up in front of a jury and a judge and they are acquitted, and it's later found that they actually did it, they cannot be brought to trial a second time and convicted because of the double jeopardy provision. So, how could they possibly bring somebody to trial a second time on the same or similar facts? Jillian?
Isn't it they find more information on like another case or like investigation of the person saying we're considering
If there's additional evidence which provides the same power and the same information as the evidence that was used in the first trial, which can now not be used, then a person could be brought up. Because it's just like taxation, it's not what you do, it's how you do it. It's not the facts, it's the new facts. Right? Then, it creates the right to due process. Yeah.
I have a question. So let's say I drive like 3 states over, and I go pick up something illegal and I'm bringing it back to those states. Wouldn't that charge me for like the custody time for every state I've been to?
Oh, yeah.
So isn't that like the same thing as like the same crime?
No, because you're in different states. The facts are different. Indiana, Ohio, and Pennsylvania. Different law, different state. One would try in, second would try in, third one would try in. It creates the right to due process. Due process has 2 flavors. The first flavor is procedural due process. That means when we talk about judicial processes, we're going to talk about how everything has to be done in the right order. If it's not done in the right order, and something gets left out or brushed aside or something like this, it can be declared a mistrial, or it can go up on appeal and the individual can be acquitted. Yes, sir.
Does the mistrial work the same way as an acquittal? And can you not, like, does it fall into double jeopardy?
Acquittal, mistrial is not double jeopardy. A mistrial is when the judge says, there's something wrong, but they realize it before they get to the verdict. And they say, it went to the jury, and the jury made a wrong decision because they could not actually get a majority or get that. Then that would be a mistrial, or some facts comes out. But there's just all kinds of things that can cause a mistrial based on what state you're in and what the procedure is in that state.
So,
Double jeopardy is not the same. Double jeopardy, you've gone all the way through the trial and been found not guilty.
right, but I was saying, in the case of a mistrial, do you restart the trial from scratch, like, or does the evidence need to be reintroduced?
Yeah, you go back right to the beginning. You start right from, and we'll talk about what the procedure is, and just go right back to the beginning. You pick a new jury, and it's in front of the same judge, usually, unless that judge recuses himself. But it will just go through the same process, the same way. Yeah. The other due process flavor is substantive due process. Substantive due process is due process that's created because whatever you're dealing with deals with a certain specific state law or federal law. If there's a trial in state court, the state law that is being used for the trial has to be the correct one. If it's a federal law, it has to be the right federal law, because there can be different federal laws and people can make mistakes on which law applies in which instance. So substantive due process accrues there. Most mistakes are made due to process, not substance. Okay? Then, it also provides that government can't take private property for public use without just compensation. If a utility wants to run an electric line right through the middle of my house, they have to buy my house, and they have to give me fair market value for it. And if I say, no, you can't have it, they can take me to court and do what they call condemn the property. If the property is condemned, I don't have any choice. I have to move, and they pay me fair market value as set by the court. The Sixth Amendment. Sixth Amendment provides the right to a speedy public trial with an impartial jury. We emphasize an impartial jury because what is speedy? What would be a speedy trial?
Something that we don't have to go after the court, but you can do like a step negotiation or something.
I like your definition better. Quick. Speedy trial would be quick, but it's quick as it can get under the circumstances. There might be 400 cases in front of it, and it might take 2.5, 3 years to get there. That's speedy under our law. Some things take a long time. Trials are limited. It provides that the citizen has the right to know what criminal accusation they face. So when they take them in, it's usually at booking or at the first appearance in court, they are read the charges against them. I mean, you see on TV shows where the person says, why are you taking me in? Why are you doing this? What are you charging me with? And it's very difficult for the police officers to say because they have to be written up properly. So based on the circumstances of what the police say in their report, and only the district attorney can do that. So if someone is charged finally with assault and battery, what is written in the report has to reflect that someone was injured, the other party was afraid, there was apprehension, they were hurt, something like that. There has to be something that is written up, and then the charges are actually read to them by the judge. So they have the right to know that, though. They just can't be put on trial for something they don't know what it is. Because they have the right to an attorney. And how's the attorney supposed to know what his defense is? And attorneys have the right to all the various evidentiary items that they need to provide a zealous defense for their client. And they also have the right to have witnesses both for and against. So I can present witnesses for me to defend me, and I can have witnesses presented by the other side against me. And it will go both ways. Okay, that's the Sixth Amendment. The Seventh Amendment. The Seventh Amendment states that common law suits must have a value exceeding $20 to get a jury trial. That $20 was in there back in the days the Constitution was first written, and $20 was a lot of money. Now, it has been changed so that the matter in controversy has to exceed $75,000, which is a little more than $20. Then they have a right to a jury trial. Now, that's at the federal level. It's much lower at the state level. And it's written higher at the federal level because the federal prosecutors don't want to have to try all the cases that they're gonna have to do if it's only $20. There'd be a whole lot more for them to do. They don't wanna do all that. I mean, who could handle all that? Right? Any questions on that? The Eighth Amendment says the government will not set excessive bail. But what is excessive? It has about the same definition as quick or speedy trial. Excessive bail is, when bail is set, it's meant to make sure that person stays where they are, right? So what's excessive? How much does it take to make sure that they don't leave? Right? And it prohibits government imposition of excessive fines. Well, what's a fine supposed to do? It's supposed to punish the person. So what's excessive? What's excessive for me might not be what is excessive for someone who is a known millionaire. It's all relative. There's a lot of relativity in the law. And it prohibits cruel and unusual punishment. So what is cruel and what is unusual? Most of us have an innate sense of what is cruel, right? And most of us have an innate sense of what is unusual punishment. What's unusual is stated in the law. What is unusual is something that's not been done very often before. It's something that is cruel is something that inflicts exceeding pain upon an individual as part of their punishment. Right? And again, there's all sorts of arguments about what makes up cruel and unusual punishment. The Ninth Amendment. It says that although our Bill of Rights gives us certain rights, when we name those rights, it doesn't mean that other rights that it doesn't talk about are excluded from us. And I'll give you one right away. The right to privacy. Does anyone know where the right to privacy comes from in the Constitution? Most people don't. Because it's not explicit. Nowhere in the Constitution, the Bill of Rights, a state constitution, anywhere, does the right to privacy exist as a right. But that doesn't mean we don't have it. That just means that it's there, but because we exist, and the Ninth Amendment says that we can have it, it exists. It is ours. We possess it. So the right to privacy comes from not just one of the constitutional amendments, but several. The First, Third, Fifth, Seventh, and Ninth. 5 amendments to the U.S. Constitution are what make up the right to privacy. But nowhere will you see it named in any of the amendments enumerated in the Bill of Rights. Okay? And what I mean by ambulatory means that this is applied down through the states as well. When it's ambulatory, ambulatory means it walks, and it walks means that it's applied down through the states as well. The 10th Amendment provides that powers the U.S. Constitution does not give to the federal government is reserved to the states. So if the Constitution doesn't say anything about a right, the states have it, and the states can apply it. A lot of these things are management tools that the state uses for its citizens, like contracts. Although the U.S. Constitution in Article 2, Section 7 talks about contracts, the federal government abstains from the application and prosecution of contractual rights interferences, which means they don't try contracts unless they absolutely have to. Federal judges hate contracts. Oh, passion. Marriage is a state level regulated item. So states set the parameters of marital rights for their citizens. Marital rights also means getting out of marital rights, not just creating marital rights. Adoption, and there are others too that the states apply. One of them the states have a right to do is to expand voting rights. They also have a right to make sure that the voters who are on the rolls are voting regularly. How many of you vote? So just everybody better vote. Because you know what happens in some states if you don't vote for 4 or 5 years? You're purged off the rolls. This used to be a very common thing in Ohio when I was growing up. Every 3 years you had to vote at least one election. If you didn't, your name was purged right off. They're doing a lot of that all of a sudden. That's why everybody needs to make sure you're registered and that you vote regularly to maintain your registration. That's one of the things that states maintain is voters' rights. The Equal Protection Clause prevents states from denying the equal protection of laws to any citizen. So laws that apply to me apply to all of you as well. It combats discrimination since it applies wherever the government treats certain individuals differently than others in similarly situated actions. The Defense of Marriage Act was declared unconstitutional in the second session of the U.S. Supreme Court in 2012-2013. What was the Defense of Marriage Act? You're close. It said that marriage is between a man and a woman. The U.S. Constitution says nothing about that. That is reserved to the states. So under the last set of amendments we were talking about, it's the states that govern that. That's why I had marriage up there. That's a good answer. You guys jumped in. So, it provides for citizenship too. All those born in the United States and naturalized citizens are under the Equal Protection Clause. Not all countries do the same thing. The Equal Protection Clause gives individuals who come to our country and are naturalized citizens the same rights as if they were natural-born citizens. In some countries, you must do one of several things in order to become a citizen, if you are not one when you enter the country. One of them is to marry a citizen of that country and stay married for a certain period of time. Another one is to live and be employed gainfully in that country for a certain period of time. That includes paying taxes, etc. Being a peaceful citizen, law-abiding. So there are times in various countries when there are differences between and among what creates a citizen. Right now, there are some women who enter the United States for purposes of having U.S. children. Anyone heard about that? For a while, there was quite an industry in China sending pregnant women over here to give birth in the United States. Their children.
Wasn't it because they don't certify kids in what they have? They're child laws?
It has to do with child laws. It has to do with U.S. laws. The children that were born in the United States were dual citizens of both China and the United States. They qualified for rights and privileges in the United States and in China. So they could go to school here in the United States if they wanted to, in our public school system. Or they could go to China if the school system was better there at that time. So there was quite an industry to ensure that mothers were having babies in the United States. So other democratic countries deal with it in various different ways. So we don't know exactly how we're going to deal with this fairly and equitably in the future. It's just going to be another development that our country has to come up with. Let's see, how are we doing here? I want to check these slides, because I don't know about you, but I'm getting a little tired.
It's 3 more.
There's only 3 more. Let's do it. We're still gonna be out of here in 10 or 15 minutes. Strict scrutiny. There's some tests when judges at the appellate level look at cases, and they're looking at appeals, and it goes to the Supreme Court. They're going to look at the various items and arguments in those cases and the facts, and they're going to judge either by strict scrutiny, intermediate scrutiny, or rational basis tests. The first one, for strict scrutiny, applies to suspect classifications. These are classifications which involve individuals that are trying to exercise a fundamental right but are being prevented from doing so, such as voting or getting married or something. And that scrutiny to promote a compelling state interest to prevent them from doing whatever it is they want to do or are trying to do. The Voting Rights Act of 1965 was declared unconstitutional in part, that is Section 4, by the Supreme Court in 2013, because the language is outdated and was subject to misinterpretation. The problem is the Supreme Court expected the Congress to take that up and redefine voting rights across populations immediately, and it didn't happen. Intermediate scrutiny applies to classifications based on gender or on the legitimacy of children. This classification is allowed only if it's substantially related to some important government objective, such as determining citizenship. So, intermediate scrutiny, trying to determine if a child is a citizen, would have an intermediate scrutiny test applied to it. And that would be an important government objective, because if they were found to be a citizen, they could vote in the United States and receive benefits and privileges. The rational basis test is the very lowest and most basic test. The rational basis test applies to everything else. This classification is allowed whenever it advances a legitimate government interest. That is the lowest test possible. Advancing a legitimate government interest. Does it or doesn't it? You know? Strict scrutiny is much harder to pass. Intermediate scrutiny is difficult but not impossible, and it's limited in what its groups are that can be applied to, and rational basis test is the easiest of all of them. Full faith and credit. I talked about due process already, substantive and procedural. But let's talk about full faith and credit. This is one of the things that a lot of people know, and they hope will be applied in whatever case they're working with. Sometimes it is and sometimes it isn't. Sometimes they don't need it. Full faith and credit is when I do something in one state, and I go to another state, and I submit it to their courts, and that court says, yeah, we do it the same way, and they certify it, and it can be, the order can be carried out in a different state. For example, if a custodial parent takes a child to a different state And the agreement for custody says that both parents have joint custody, but now that this parent is in another state, there are laws there that say they don't quite have to do things the same way. The custodial parent, or the agreed upon custodial parent, when they're sharing custody, can file for an order in their state, probably where the separation agreement and the custody agreement was executed, have it certified by the Supreme Court in that state, and carry that order over to the Supreme Court of the state in which the other custodial parent is residing with the children, in order to make that parent abide by the agreement that was executed in the prior state. That's full faith and credit. What was done in this state is given full credit in the other state. Does that make sense?
Yes.
Okay. That's a very good thing to remember if somebody ever runs out. Privacy rights. Privacy rights are guaranteed by both state constitutions and the U.S. Constitution. The First, Third, Fifth, Seventh, and Ninth Amendments. Sometimes state constitutions actually have amended their constitutions to include the right to privacy as a provision of the Constitution permanently. And then we have executive orders. Rights granted by executive orders. People somehow, sometime thought that executive orders were not law. Executive orders are law. They're the lowest form of law. They're below regulation. We have the Constitution, we have statute law, we have regulations, and then we have executive orders. They're no less enforceable. And the courts will take them up and will enforce them if they are constitutional. The difference with an executive order is, and a regulation or a statute, the executive order expires as soon as a new president or a new governor or a new mayor takes the oath of office. In other words, executive orders are personal to an executive authority, and they just vanish. So where do we have all the executive orders that are applied in our country right now? Well, they're in these huge binders, and every time we have a new governor, a new mayor, or a new president elected, they take their own set of binders and they take them into this little room. Sometimes you wonder why it takes time for the person who's going to be inaugurated, when they always show them pulling up to the Capitol, and they get out and they go into the Capitol, and then you don't see them for 2 hours. You know what they're doing? They're signing all the executive orders from the previous administrations that they liked and are going to keep, and they're signing new ones that they want to incorporate, because all of them have expired. And they have to re-sign them all because they are personal to that particular executive. Okay? We'll probably go over this again when we get to administrative law. Supreme Court decisions, we have 3 parties and 3 flavors to any Supreme Court decision and any appellate court decision. The first one is the appellant's view and what the appellant wants. The second one is what the appellee wants. And the third one is what the court, whether it's the Supreme Court or whether it's the appeals court, actually said. And there's always going to be disagreements, right? That's what precedent's all about. That's what continuing development of the legal system is all about. And that's it. That's it for tonight. That's it for our constitutional. We'll move on from here in the next one.